This is Professor Richard Cupp. He's a professor here at... Some of you may know him. Professor Cupp's a professor here at the law school. He's been published in the New York Times, LA Times, USA Today, Philadelphia Inquirer, National Law Journal, Indianapolis Star, other media venues. He's just widely known, a brilliant mind. JD from UC Davis in 1987 was magna cum laude in his undergrad here at Pepperdine in 1983. So I think we already gave a round of applause, but let's have a round of applause for Professor Rick Cupp. And joining him is really, truly, these are amazing panelists. And for anyone who's in the practice, these are not names that you're unfamiliar with. Or the bio that I go through is probably something you've heard at various conferences. But we're very proud and honored to have these four people here with us today. And for the students, I'll give you a little sense of who they are through their bios, but just an incredible group of men. Rex Paris is recognized as one of the most successful and innovative trial lawyers alive today. Rex handles a wide variety of cases ranging from severe personal injury to class actions, products liability, and business torts. When he's not in trial, Rex tours the country speaking to trial lawyer organizations about the intersection of cognitive science and the persuasion of jurors. Rex has been profiled in numerous national media outlets, including 2020, Nightline, The Wall Street Journal, LA Times, and a myriad of other legal journals. Rex obtained the first $1 million verdict in California's Kern County as a young lawyer, and years later obtained a historic record-breaking defamation jury verdict in Los Angeles for $370 million. In addition to managing his trial calendar, Rex also manages one of California's fastest-growing cities. As the mayor of Lancaster since 2008, Rex has gained nationwide media attention for his efforts to improve the well-being of the city's residents. Rex and his wonderful wife, Carroll, founded the firm in 1985 and worked tirelessly to improve the service and results they provide today. Carroll and Rex are the founders and benefactors of the Paris Institute for Professional Formation here at Pepperdine Law, an institute dedicated to the professional development of first-year law students and providing continual mentoring throughout students' law school careers. The institute launched in 2014, focusing not only on professional development, but on health, personal goals, some of the things that we heard about from Spencer Lucas a moment ago, training, ethical attorneys, and every aspect of their soon-to-be professional life. I don't know if Carol's in the room, but I'd love to recognize Carroll and Rex Paris. Thank you for being here, and let's have a round of applause for them. Sitting to Mr. Paris's right is Mike Bedard. Mike Bedard is the managing partner of Chernoff Bedard Echeverria and is a preeminent consumer attorney who has had a major impact on our healthcare system. He leads his firm's HMO litigation and property casualty departments. Mr. Bedard's inexhaustible efforts were showcased in a $120.5 million jury verdict against Aetna over his refusal to pay for care recommended by the health plan's own physicians. It was the largest jury verdict ever rendered against an HMO at that time. Recently, Mr. Bedard obtained a $28.2 million jury verdict award against Kaiser Permanente for a 17-year-old cancer survivor. In 2016, he was named Consumer Attorneys Association of Los Angeles Trial Lawyer of the Year. In 2011, he was named California Chapter of ABADA's Trial Lawyer of the Year, and has also been named a top 100 Southern California super lawyer every year since 2004. In 2015, he was listed in the top 25 plaintiff lawyers in California by the Los Angeles Daily Journal. Bedard is a fellow of the American College of Trial Lawyers, the International Academy of Trial Lawyers, and ABADA. Mr. Bedard graduated from Pepperdine Law in 1974, the year after our good friend Judge James DeCesar, and we are always honored to have Mr. Bedard join us. Please welcome him. Sitting to his right is Brian Panish. Brian is one of the country's leading trial attorneys and has obtained some of the most significant jury verdicts in the United States history on behalf of plaintiffs. His courtroom victories include a $4.9 billion with a B record verdict in the landmark products liability case Anderson versus General Motors, over 75 verdicts and settlements in excess of $10 million, and more than 250 verdicts and settlements over $1 million in personal injury, car accidents, wrongful death, and business litigation cases. Mr. Panish has also obtained 5 jury verdicts in excess of $50 million. And since 2011, Brian Panish has obtained more than $300 million in verdicts, including, among others, a landmark approximately $54 million verdict for 2 Southern California brothers who were severely injured following a head-on collision.
We did that one together.
Oh, that wasn't in my bio, I'm sorry. Mr. Panish has been appointed to serve on the plaintiff steering and executive committees in numerous high-profile mass torts and major disaster cases, including litigation involving train crashes, airplane disasters, and pharmaceutical cases and defective product cases. Mr. Panish has been recognized by numerous publications and organizations as being among the top trial lawyers in the country. We are always honored to have him join us, and this is, I believe, the 4th time he's been here with us. Please join me in welcoming Brian Panish. To his right, Mr. Mark Hiepler. Mark Hiepler is a graduate of Pepperdine Law School, 1988, and is the current co-chair of Pepperdine Law's Board of Advisors alongside Federal District Court Judge Jenny Dorsey. Mark has been called the nemesis of the HMO industry by 60 Minutes. During interviews with reporter Morley Safer, he's renowned for his many landmark jury verdicts, ranging from his record-setting $89.3 million bad faith verdict on behalf of his late sister, Nalene, to a $120.5 million verdict against Aetna for its refusal to pay for healthcare recommended by its own plan. Mr. Hiepler's landmark jury verdicts have been featured on national television shows such as 60 Minutes, 2020, Nightline, Burden of Proof, NBC's Nightly News with Tom Brokaw, The Today Show, and The Oprah Winfrey Show, which there's a clip on YouTube for those of you who are interested. If you're on Oprah, you're kind of a big deal. Mr. Hiepler was voted one of the top 10 Reader's Digest, one of the top 10 trial lawyers in the nation by Trial Lawyers for Public Justice, and one of California's top 100 most interesting and influential healthcare leaders by readers and editors of California Medicine, and named one of the 100 most influential lawyers in America by the National Law Journal. Mr. Hiepler has been selected as a super lawyer every year since 2008. 2018, an honor bestowed to him by peer review. In 1994, after the verdict in Nalene's case, Mark and his wife, Michelle, a successful and noted attorney in her own right, formed the law firm of Hiepler & Hiepler, which is located in Oxnard, California today. Please welcome Mark Hiepler. And our last, but certainly not least, Titan is sitting on the far right. This is Mr. Mike Arias. Mike is the founding and managing partner of Arias, Sanguinetti, Wang, and Torrijos, LLP. He is the 2018 president of CAALA and president-elect of CAOC. During his nearly 35-year career, he has litigated and tried matters throughout the United States in both state and federal court. He has served as lead, co-lead, or liaison counsel in well over 100 class and mass tort actions. His last 10 trials have included serious personal injury, wrongful death, employment, consumer class actions, and mass wage and hour claims. He's recently resolved several class actions and multiple plaintiff matters involving antitrust, toxic torts, consumer, wage and hour, environmental issues, and product liability. During his career, he's resolved hundreds of matters, resulting in hundreds of millions of dollars in recovery for the firm's clients. Mr. Arias is a member of the American Board of Trial Advocates and was selected a 2018 California Top Plaintiff Lawyer by the Daily Journal. He holds an AV rating by Martindale-Hubbell and has also been selected annually as a Southern California super lawyer. Mr. Arias is also a Pepperdine Law School alum of 1984. Please welcome Mike Arias.
Thank you, Ben, so much. Ben was one of my favorite students when he was a law student here, and it has been so much fun for me watching him do amazing work, making Pepperdine even better for its students and alums. So thank you, Ben, for that. I'd also like to thank everybody who's helped make this amazing conference possible. It's so wonderful being here in the new Caruso Auditorium, seeing it filled to the max, knowing it's overflowing. And I got to tell you, you made the right choice in coming here today. This panel that we have before us has been described as the panel of the Titans, and it really fits. I'm so excited to get to chat with the 5 people to my right. It is an incredible collection of talent with trial lawyers that we have here today. In fact, I was thinking about it this morning. I cannot think of a panel that I've ever moderated that has had a more impressive group of individuals in their field. So you're in for, as you probably know, as those of you who are lawyers know better than me, you were in for a wonderful treat with this group. So let's go ahead and get started. I think I'll just start here to my right and move down with questions. And I'll ask this question of everybody. Let's start with juries. And we're focusing some in this panel on mistakes that you have observed and that we can learn from with those mistakes, because we, of course, know we all learn the most from mistakes. So let me start, Mr. Parish, with Mr. Paris, with you. With regard to juries, what sort of mistakes have you observed, or what is a mistake that you have observed with a jury, or I'll broaden it a little bit, with any trial matter, any sort of preparation for trial or activity during a trial that you think can teach us something?
So you want one of the thousands of mistakes I've made with jurors.
Pick your top 10.
You know, I think the biggest mistake that I made over the years was not recognizing that the most important thing you have out there is your credibility with them, how sincere you are, you know, and I'm always getting drawn towards a trick, you know, something that I read about or saw, or something I'm trying to force into into a round hole that just isn't there. And once I figured that out, and I will give up points, I'll give up anything as long as I preserve that credibility with the jury. And that means not being a fraud at any time. If it's funny, laugh. If it's not funny, don't. You know, if it's being in the moment with them. One time, Brian and I were trying a case, and I was worried about how the jury was reacting. And he goes, "They're supposed to be suspicious of you. It's going to take about a week before they start realizing that they can trust you, they can rely on you." And ultimately, that's really what you're aiming for, is that you are the most credible person in that room. And once you get that, I think you're pretty much there, as long as your client doesn't screw it up.
Mike?
Well, 2 things. First of all, on the subject of mistakes with juries, I think it's a mistake to think that you can really condition a jury to your case during the few minutes you have with them. I don't think you're going to change who they are in just a few minutes. And so I think it's a mistake, and I've made the mistake myself earlier in my career of trying to change their mind if they say something that's bad about your case, and really getting nervous and freaked out if they come out and say something that's really embarrassing or whatever. For example, well, we all know there's only one reason you're here. You're hoping to make a big fee out of this case. And to hear that and not react to it takes a lot of maturity and a lot of confidence. And so I think the real purpose of it is to identify who they are by listening to them and giving them a chance to talk, rather than you be the one doing all the talking and try to give speeches and convince them of your position. That's just a personal belief of mine. As far as mistakes generally in courtrooms, I listened earlier when Dave Wheeler was talking about dealing with millennials and making sure that you're not getting buried in your notes. I think that goes with any jury at any age. Every minute you spend with your head buried in a bunch of notes and legal pads and standing behind a podium, and I love it when my opposing counsel stands up and puts a podium between him or her and the jury and has a long list of notes on a yellow pad. The more pages, the better for me, if they're spending their time reading their arguments to the jury. So that's 2 areas that I think are common mistakes.
Thank you. Brian?
Preconditioning that Mike talked about, thinking you can argue your case. People today are too suspicious, and that doesn't work, and I used to do that a lot. I don't do it now. And I think a lot of it has to do with being yourself. When you first become lawyers, you come and you see Rick Friedman and you want to be Rick Friedman, or you want to be Rex Paris or Mike Bedard. But it's hard to be someone else. That's why it's hard to be an actor. So you need to be yourself and be comfortable with yourself, and that'll make you come across as a nice person, because you are, and people will want to talk to you more. So you want to ask open-ended questions. You don't want to be the center of attention. A lot of lawyers have egos, and they want to always be in charge. But in the voir dire, you're getting information. You want to let the jurors talk. The more you let them talk, the better you're doing. As far as mistakes, well, I've made plenty of this. I guess he's reminding me that this is the 4th time I've been here on this mistake, so I have a lot of mistakes. I hope I'm running out of them. But I think mistakes, number one, thinking you can convince anyone. You know, there's jurors that come up that have a bad profile, and I used to think, well, he likes me or she likes me. Forget it. You can't convince everyone. Accept it. Find out who the leaders are in the jury. Hopefully they're open-minded, will give you a fair shot. But if you think you can convince everyone, you can't. And finally, I would say credibility that Rex talked about is the key of all trials. And it starts with the voir dire, and it starts not only how you question, but how you treat other counsel, how you respond to the judge, what kind of civility are you showing in the courtroom. Because at the end of the day, whether you're representing the plaintiff or the defendant, the jurors, if you're asking for money, they don't really know anything about it. It's foreign to them. So if you've built up credibility with them, at the end of the day, you're going to cash in the final argument. And if you're able to logically put your case together following the law, and the jurors think you're a believable person, they're going to go with you. And that starts from the minute you show up. Not when you go in the court, it's when you're in the hallway, when the jurors are around, when there's a break, how you treat the court staff, everyone. And it starts from the minute you're down there till the case is over. So, thank you.
Thank you. Mark, and I want to note that I brought, this is broad enough to include matters at trial as well as juries.
Without repeating exactly what they said, and that's all fabulous, I've learned from everyone at this panel and asked them questions about things, and they, as well as people in the audience, have been keys to any kind of success. I had my wife, I see Dean Phillips, and Glenn Campbell. The more people you can get, and that was probably one of the mistakes I made really, really early, was I was a little afraid to call these people, afraid to go to a Chernoff seminar. And the more I could get information from people that I'm surrounded by, including Pepperdine Law students, the better. So that was a little bit of a mistake, because I thought, well, they're never going to return my call. And all these guys here, and even the ones that aren't from Pepperdine, are so gracious to help everyone in trial. And we have a congeniality about it. Hey, here's the defense attorney we're up against. What's his tricks? What do you see? And all of those things are great. But specifically building on what they've said, I've been criticized. If you're a poor shooter in basketball, you got to get a lot of rebounds and you got to use your elbows. And I was never a good shooter, so I was very competitive. So early on, I had jurors afterwards say, you got to cut down that nonverbal behavior. You're whispering, liar, liar. And we know he's lying. But it ticked him off that I was saying liar. And then when you come back from getting beat up in the back by the jury or by the judge on a motion or a sidebar, I would kind of show it on my face when I came out. And very smart people and the jurors afterwards said, come out not showing, your grit and that you're sweating and that you're pushing the guy. Just come out with a real pleasant attitude. So nonverbal behavior and then learning from all these people.
Mike.
I had a list because the questions were given to us before we got here, so I actually spent some time to come up with some mistakes, and of course most of those have been hit on, so I scratched them off. But I'll talk about the ones that I still think are important. One is and this is focusing on the mistakes at trial that I think I've learned over the last 30-plus years. And one of those is the impact sometimes you have on juries when you are beating up on a witness. You got a bad expert or a bad defense expert, and you can't help yourself. You want to beat them up. You think that's going to help. What I've learned over time is juries will sometimes think you're a bully. So don't, even though you can just kill them, you got to learn to control that, because jurors are humans and they have feelings, and when they see that you are overly attacking someone, it can actually sometimes hurt you. I also think sometimes we forget we're trying the case to the jurors, that they're the trier of fact, and they're the ones you want to satisfy. And we try the cases to other people in the courtroom, your client, the judge, everybody else. So I always try to remember the 12 people in that box, and you can sometimes forget that in the heat of the battle. The other is a respectful demeanor towards everyone. Everybody up here, I guarantee you, has worked with defense counsel that tend to be, I won't use the word, but you just don't trust them, you don't like them. But you've got to keep that demeanor that looks respectful. Sometimes you want to be sarcastic. They're sarcastic. That, again, I find in talking to jurors, that turns them off. And if you have a really great case and you're going to win, maybe some of these things won't apply because you got great damage and great liability. It's those cases that are the ones that you're trying because they're the ones that need to be tried and they're tough liability cases. These little things do have an impact. When those jurors get back in that room, they talk about it. And they talk about it during trial when they're going to lunch and they sit together. They're not supposed to talk about trial. You hear jurors sitting at lunchtime talking about, boy, that guy's, that guy is just, they don't like him. So those types of things can hurt your case. And the other thing I think is sometimes we're so into our trials, we don't read the juror. As we're presenting evidence, we don't look at them. We don't kind of see how they're receiving it, their facial expressions, the way they do things. I think it's an important part of it, not just putting on your evidence, but watching the jury and how they're reacting. And I think we tend to forget that because we've done it so long, it's kind of a natural progression for us. The other thing I will say is, and a comment was made, I think, by Brian, you're not going to change a juror that's, when you've used all your peremptories and you got a couple left, you're never going to change them. What I think you want to try to do is get them to understand your case, at least understand it. You may not get them to vote your way, but at least get them to hopefully understand it. So I'll spend a lot of time with those jurors and making sure when I'm talking to the witness, I'll look at that juror right in his eyes, and hopefully he's perceiving and understanding what I'm trying to come across. And the last thing I do, Brian said it, Brian teaches on, CAALA has a Plaintiff's Trial Academy we started 6 years ago. Many of his graduates I see here today. And one of the things we tell them, because we have the best trial lawyers in LA teaching them how to try cases, I tell them, you're not here to become Brian Panish. You're not here to become him. What you want to do is be yourself, but take the skills and things he can teach you and make sure you're always authentic, because the way Brian does it, it may not work well if you don't have that same kind of personality. So those are the things I think we tend to find that jurors pick up on relatively easy.
Thank you, Mike. Okay, professionalism and difficult people. Lawyers are always running into difficult people, and there are professionalism questions that come up. So the next question is, what sort of mistakes have you observed regarding with professionalism or difficult judges, opposing counsel, or even expert witnesses, or any person is involved in the litigation process? And I'm going to rotate where we start. So let me start this one with Mike Bedard.
Well, I had, actually, after 44 years of practice, I had one of the most difficult opposing counsel just a couple years ago. And when I started the trial, thanks, Brian. That's another mistake. Don't stay too close to the microphone. When I started the trial, I was getting calls from people because I think that my hope is I have a reputation for getting along with opposing counsel. Because when they start really treating you poorly or exhibiting really aggressive behavior or just being downright unreasonable, I think the most important thing you can do is just be the opposite. Don't let it get to you, no matter what they do, whether it's before the trial starts or during the trial. Jurors are smart, jurors are observant, and they can tell. And by and large, if someone is being unreasonable or being mean or unreasonable throughout the trial, if you just don't let it get to you, that's going to be very important. Having to do with a judge, that's a different problem, because you have, normally, most jurors will take leads from the judge. They don't know how the system works. The judge is in a position of responsibility, and you have to be very, very careful to openly let a juror know or a jury know that you are not happy with the judge or the rulings. That's very dangerous territory. Having said that, after a while goes by, sometimes the judge is so bad that even the jury starts to dislike the judge. So that if you find yourself, now you can kind of start getting body language from your jurors or making faces when the judge does something. Now you can take a few more liberties in terms of letting them know that you don't like the judge either. So those are just some thoughts.
Thank you. Brian.
Okay. I have one lawyer that I've been against at least 50 times. At least. But this year we did our 4th trial. Now we've done other trials that settled, but 4th trial to verdict. You know, me and him, and others obviously. And I've been in trials where he's told the judge that I threatened to, you know, do things to him, or that I've cussed at him,
It's not true.
or that I've, you know, made faces at him, and that I've engaged in improper conduct, and I've attacked him in arguments, and all these things. And he actually has a motion in limine that the exhibits are like 3 inches thick, where they have every transcript for the trial, what I said, what the judge said, and every little, what they think tactic I use. So in October, I had a really good case, and he was against me. And I said, this time, I'm not gonna let him get me upset. And I'm a competitive person. And so, so the whole trial, I kept saying, you're not gonna get me. It's okay, go ahead, whatever you want. And I didn't wanna screw up the case because, like Mike said, you don't wanna be a bully. You don't wanna be dominating everyone. If you have a good case, you want the case to speak for itself. You don't want the lawyer to be the one being everything. It's all about the case. So it even got to the point, so we go through the trial, you know, there are fights and all this, but nothing improper. And the judge was ruling my way. It always helps when the judge gets it too, even though the judge lets them go on, which I can't take it. But the judge lets them go on and on and on. And you're like, come on, judge. So he does this one objection in my final argument, approaches the sidebar. He's done it 5 times on this one thing that I argue. The judge overrules him. I get back. I start talking to the jury. He objects again. And in the opening statement I was giving, he objected, and he told the judge that I glared at him when he objected, and I looked over. Which I go, Judge, it was a ridiculous objection. Then he said I laughed at one of his things in his final argument. I said, yeah, I laughed because you put up that picture of your expert from 40 years ago. So anyway, he starts objecting, and I just looked over at the jury. I said, you know what? That's okay. That's his job, to minimize the damages, to keep the verdict down. And if he wants to object, don't hold it against him. It's okay. That's his job. And the guy's looking at me like, are you kidding me? And it turned out great. And Spencer, I heard Spencer Lucas talk about working out. I was working out in that trial every day. I was feeling so strong. I think you have to work out in trial. Alex will give you the plan. I'm sure he has it. But I do think it's important that you're getting enough sleep. I never, in law school or ever, stayed up all night to study, okay? Because I get too tired. So, whatever. I never do that because you're not yourself. The next day, you're not feeling so good. I mean, maybe you all can stay up all night. I can't do that. I'm not good at that. Maybe in college and alcohol and other things, but not now. So get your rest, because I think if you want to be sharp and you don't want to lose your cool, when you're rested and you feel good, there's less of a chance of it happening versus you're really tired and you got a runny nose. I mean, everyone, when I'm in trial and I'm sleeping, I see all these other lawyers are getting sick. They got colds, they're coughing. Like, what's wrong? And I get enough sleep, huh? So There was one other thing Mike said that I wrote a note. I can't remember what it was, but I'll get back to it. Mark, thank you.
I think not responding immediately. I used to respond, and you know, I knew it. I knew it all. And originally, I was only surrounded by really old guys, and you know, they'd be like, "Geez, you're this young punk," and so I would respond and just try to prove it. And I think that over time, the lack of a response, the pause, like I tell my own kids, you know, hey, you know, let that guy obliterate himself and just go down that path. But one of my sons plays college basketball, and there's a guy that's always on him telling him how bad he is. And I just say, hey, go tell that guy, you're the best guy in the world, man. You are Michael Jordan. And he shuts up. And he goes, Dad, that really works. So I have just moderated my response to the other side. I always tried to be as gracious as I can. You can't do it all the time. The worst person I've ever been up against, and it was a 4-year situation. It involved a quadriplegic. It was kind of the first time I started implementing this. And maybe 8 years later, this guy comes in a wheelchair, and I looked on you know, we'll take a little intake form. Who referred you? And I'm like, this guy referred you? Go, did he tell you about us? And it was the most despicable defense attorney I have ever had. There was no one in second place, and this guy had referred us. And so you never know where that next call, that next case may come from. And I thought of all those times that I wanted to unleash on this guy, and at the end where I wanted to, like, you know, then stomp on his head, because fortunately we were in that case able to win. But I was so glad I didn't. And then I got to meet this whole other family. So, you know, being reserved and being gracious goes a long ways, but it's so hard.
Yeah, can I say one thing, Rick? The one thing I remember now is as Mark called it, the nonverbal. It's not good. And I've been doing it for a long time, and I'm really trying to cut it back. The juries don't like it. I mean, you know, like the eyebrows, you know, the dropping your pen, you know, that they don't dig it. And it's hard because you're so competitive and you're in a stressful, intense situation. But as Mark says, take a deep breath. Take a pause. This is not helping you. And you're probably bad on the nonverbal too, right?
Oh, yeah.
Liar!
Mike.
Thanks. So the topic was difficult counsel, difficult judges, and difficult clients. As far as defense counsel goes, my philosophy is that I've always been, they're part of the process. You don't have litigation without them. They're doing their jobs. I think if you automatically assume that they're doing their job, you kind of understand that's going to happen. I think a lot of it depends. Probably the 5 of us up here don't get, you know, don't have to face all this stuff a lot of younger lawyers do. So I always hear from the younger lawyers, their interaction with defense counsel. They won't do a lot of that stuff to us, although they still do it to Brian because they love getting him riled up. But I think that's, you got to go in with that mentality. But here's the thing, don't always feel compelled to go tit for tat or get sucked into that. Because a lot of times that's their mentality. That's why they do it, to get you going. And apparently it does work well with Brian. But the other is turn the other cheek. It's the old adage, don't respond in kind, because I think jurors and judges pick up on that. You gain more respect by them doing that and you just not responding. Jurors have told me that. They've made comments about my opposing counsel. Another thing is, I say this early on, learn to dissuade that kind of defense counsel early on when you first start the litigation process. Probably all of us up here have associates that work up cases for us, and you don't necessarily establish relationships with defense counsel early on. It's usually later. But when I do get involved, I call them up, I talk to them a little bit. I try to figure out what's going on, especially if my associate has told me they've had a hard time. So set the tone. I set that tone right out. Here's how I'm gonna do these things, and I want them to understand it, so hopefully you don't have that problem at trial. But the one thing I will tell you is be very careful, because there are some defense lawyers who are really, really cool and good through the litigation process. When they get to trial, there's another side to them. Now, we know who they are because we face them many times, but for the younger lawyers, be a little careful of that. Judges, with a difficult judge, my advice to young lawyers, always be better prepared than your opposition. Always have everything done on time, have it done right. Judges will automatically have their respect when you walk in that courtroom. Bite your tongue when they do things and always maintain respect. But here's the key, I'll tell you, it's harder for younger lawyers, but I know we all do it, and that is don't let a judge feel that he can intimidate you. When you walk in there, he says something, he feels he's gonna kind of put his thumb on you, I stand up and I don't let him do it. I let him, He's got to respect me. I give the judge the same respect that I want anybody else in the courtroom. But the one thing I will tell you, when you have a difficult judge that's affecting your case, the key is always make your record. If a judge does something that's not right, make sure you make your record, because many times that could be the only remedy you have if the judge is so bad that you get a bad result and you have to appeal it. Clients, very simple. Here's what I say with difficult clients. Remember, everybody in this room, you work for them. You work for them, all right? And it's hard to think that sometimes, but you work for them. And if you can't get along with the difficult, then get out. So those are my thoughts.
Thank you, Rex.
You know, this is a subject that is very close to Carroll and I. That's why it's the Professionalism Institute. You know, there's a reason we think that's important. The first 20, 25 years of practice were miserable. I mean, miserable. There were times it was hard to stay alive. It was so miserable, you know? And it's because I realized that I had this view that I had to be the toughest, meanest junkyard dog on the block, you know, and I was constantly competing with the opposition. And the thing you have to recognize is you can't leave that at the office. You take it home. It becomes part of you. It becomes part of how you talk to your wife and how you talk to your children. And if you go down that path, I guarantee you will have a miserable existence. You know, maybe that's your comfort zone. So it got to the point where I thought that was my comfort zone. And for some reason, when I finally started paying attention and reading the science and trying to mold the way I reacted, everything got much better. You know, when it's not uncommon for when some guy starts yelling at me in a deposition, for me to say, you know, please don't yell at me. When you yell at me, it frightens me. And if you, well, it does. It makes my heart beat faster. And when you frighten me, I can't be a good lawyer. And my client has a right to a good lawyer. So if you keep doing it, you know, we're going to have to go talk to the judge. You know, what do you do with that? They always quit yelling. You know? and you know, when we first started this thing, it was primarily for women because, you know, my daughter was a lawyer, or is a lawyer, and we have women lawyers in the firm. And the way men can treat you is deplorable. And I mean, truly deplorable. They can become bullies. And, you know, my wife and I were concerned was, you know, how come Ashley swears so much? I mean, she went to Christian school. She went to Pepperdine. All of a sudden she's swearing. And, you know, there's a science behind that. You do that to tell everybody how aggressive you are. And so we really went out on a training program to train our young lawyers that that's not who we are. And the reason that, there's a lot of reasons that's not who we are, is if I'm in a fight with you, I'm probably going to do a better job of crossing the T's and dotting the I's. And I'm going to be much more difficult to settle with. The other thing you have to be aware of, if Brian and I start yelling at each other, how do you feel? You feel bad. You cannot watch people trying to hurt each other and not feel bad. So what does a jury do? What does a judge do? They will turn away from you. You know, and that's what we're always looking for. Are they turning towards us or are they turning away from us? We do not want them turning away from us. We are now developing a computer software program with IBM that every email, every letter is reviewed for tone. You know, is it a nice or evil letter? Evil letters do not go out of our office because judges read those letters. I mean, quite frankly, that's why you're writing the letters, in case he's going to read it someday. We want the judge turning towards us. You know? And the time to start practicing that is now. You know, at every interaction with human beings, how do you keep it, you call it professional, call it civil, call it whatever. How do you control yourself? How do you keep from becoming that jerk? Because if you're not on guard and if you're not working towards that, trust me, in this profession, you can be a jerk before you know it. Thank you.
Great. Okay, we're going to start with Brian for this next question. Gentlemen, I have shocking news for you. We have a lot of law students in the audience today. We have a lot of young lawyers. My news is a lot of people would like to work for you. Obviously, you know that. You've had thousands of people apply for positions with your firms over the years. And because we've got so many law students and young attorneys, we thought it might be helpful to present to you a question. What mistakes have you seen with regard to people seeking to obtain positions with a law firm as attorneys? And what advice can you give our audience related to that?
I can talk about that. My father was a lawyer. 3 brothers are lawyers. My wife's a lawyer. 1 daughter just passed the bar and another's in law school. So we like the profession. And I didn't push any of it, or did my father. Number one, I think the most important thing is what I see people coming out of law school, they don't really know exactly what you want to do. And to be successful, you have to do something that you like, I think. And being in litigation or being this kind of attorney is not the easiest job. And there may be other things that you like to do. So when you're in school, I think it's important to get externships with, some government agency, maybe a law firm, and then jobs in different types of firms to find out what is the area of practice that you like. What do you want to do? And I think that is the most important thing. As far as in law school, I think it's important to take classes that are going to help you in the area you want to practice, but most importantly, they're going to help you pass the bar. Because you can't be a lawyer till you pass the bar. Haven't been through it. I passed, everyone in our family, but it's a stressful thing. And in law school, you're preparing to take the bar. And I think you need to take classes that are going to prepare you, whether they're hard or not. And if you want to work in a big firm, O'Melveny and Myers or Latham and Watkins, then you got to have the best grades. But if you just want to be in a regular lawyer and in a good firm, it's important to take classes that are going to help you in passing the bar, number one, and for knowledge in the profession that you're getting into. Luckily, I was lucky when I was in law school. I had a lot of jobs. My dad was a lawyer. He told me, contrary to Rex, who's got the family law firm, he goes, you don't want to work for me. You want to go do your own thing. So I said, all right, I guess I'm not working here. And none of my brothers or me or any of us have worked together. My daughter's not working with me. But I think it's important to find out what you want to do and what you like. So,
Thank you.
Mistakes in the interview process, people don't do, again, most people do really well. If they've come from the Paris Institute, they're incredible. But I've seen ones where they don't know anything about the firm. They don't know what you do. They just want a job. And so they'll say, any questions? No. And I've asked them, do you know what we do? Well, you do like trial stuff or something. I mean, right away, that person has really wasted their own time, and however they got in the door, you're just shocked as to, who sent this person in. So know something about who you're interviewing with. I mean, with the phone, we did a demonstration in this room not long ago. 10 minutes, I learned about 3 random law students, and I could tell you all about these guys. And if you don't at least give the courtesy of that to the firm, no one's going to be too interested. Second thing is try to position your resume so that when you go to talk to Brian or Mike, any of us, hey, I can actually do something. Humble confidence. I've written an opposition to a motion for summary judgment. I've written a complaint. I've done this. Hey, I know social media. Everybody was bagging on this panel that they don't know anything about technology. Okay, be a solution. Come in and make yourself indispensable, as Alex was saying earlier. What do you have to offer? Because if you want to just be trained, you got to go to one of these big hourly defense firms like I started at, because they're going to make money off you from day one. But you've got to come to the party with something, a humble confidence, but something you can do. And you get that through internships. You get that through the DA certification, where you can try 5 or 6 trials before you get out of law school, picking a jury. So there's all kinds of ways, but come with something, humble confidence, but also know who your audience is, know who you're interviewing with, know all about Mike and his history and where he's been, because that alone can tell you a lot. Plus, he's going to like it when you ask him a lot of questions about what made him so successful.
So I think, especially those of you who still have a couple years left in law school, you're attending this conference because it's a trial lawyer conference. So apparently you've made some decision, at least so far, that you don't want to be a corporate lawyer doing real estate or doing corporate law. You want to be a trial lawyer. And so I think that's usually the biggest mistake that some people I talk to, either whether they're fresh out of law school or a couple years out, is they're not really sure what they want to do. And I want to say this because all of us up here are plaintiff trial lawyers. And there's a big distinction. And I will tell you this, and I tell, the way I kind of explain this to people is, one thing's different about us versus defense lawyers, is every one of us get to pick our clients. They walk in the door, we make a decision, whether we want to help them, we get to say yes or no. You're an insurance defense lawyer, you don't get to make that decision. They put a file on your desk, and you're going to handle that case, no matter who that person is or isn't. So you're a different breed in my view. And so, knowing that, when people are coming in, here's the things I look for, and things I think are important. If you want to be a plaintiff's trial lawyer, and I will dissuade those of you to not go there if these aren't some of the characteristics you have, because there may be other areas of the law that you may be better at. But these are the things I look for and where I think I've seen successful young lawyers become very good trial lawyers. And one is a passion for being a plaintiff's lawyer. It is something different. You have to want to be a plaintiff's lawyer, not just a trial lawyer, a plaintiff's lawyer, because there's so many other things involved in being a plaintiff's trial lawyer. I look for a diverse experience in their life. I look for people that had something in their lives. I go back. I talk back all the way to high school, sports, things like that. Find something that has been very diverse in their life. I look for high energy. This is a job. You cannot be a 9-to-5 person. You got to have a lot of energy. And 5-hour energy drinks every day aren't going to help you. So I look for that. I also look, as Brian does, and I know he does too, I look for competitive people. People in their lives have some sort, you don't have to be a football player, basketball player, but some sort of competitiveness in your makeup, in your DNA, because you have to be willing to compete, because that's what this is. Personality. I look for open kind of people that I can laugh and have fun with, that you can just, that I can tell, because that's what's going to, jurors look for. You need to have a personality to be successful from jurors. So I look for that kind of personality. I look for confidence. Here's the difference. I look for confidence, but I don't look for cocky. If I get cocky, that's not good for me. I want somebody that's going to be confident, because I think cockiness can sometimes be your downfall. And then I look in their background. Have they ever been committed to a cause? Is there something in their life where they've been committed to that shows me they have a passion and ability to grasp something and want to make a change? And that usually tells me that these are the kind of people I'm looking for. And I think most of the trial lawyers I know, when I get to know their backgrounds, and a lot of the people in the trial academy, I get to know who they are, and I go to lunch with them, I talk to them about their backgrounds. It is amazing what you hear about. It's amazing the things they've done, all right? And I think those are the things that distinguish plaintiff trial lawyers from other trial lawyers.
Thank you. Back to Rex.
They don't let me hire people in our office.
Good decision.
And no matter what happens, I mean, you'll have to go through Alex. Ultimately, you're going to have to sit down with Carroll. That can be brutal, because she's going to ask you things. She, like Mark said, do you know the firm? What have you done? What have you researched? Do you know everybody that works here? How much energy have you put into this? The other thing she's going to ask you is, what are the last 3 books you've read? And then she's going to ask you questions about them. You better have read them. Because we want people that recognize that studying didn't stop when you got out of law school. It started. That's when it started. You got to read 5 or 6 books in the firm every year that make you a better lawyer. The biggest thing we are looking for is the humility. This is really, really hard, what we do. And do you have the humility to learn it and to recognize that what you're doing today may not be right tomorrow? And and then finally, what I'm most concerned about is compassion. How do you feel about people? Do you bleed for them? And if you don't try to fake it. It's not going to work. One time, a very well-known plaintiff's lawyer offered me a job, right when I had already got the Yellow Page ad, so I couldn't take it. But I asked him, why would you want to hire me? And he said, compassion. Because I had really thought I embarrassed myself. I was taking his client's deposition who lost their spouse in a traffic collision. And the tears were rolling down my eyes as I was talking to him. You know, it was devastating to me that could happen. Do you have that level of empathy is what I'm looking for. And if you don't, be a defense lawyer. Don't be a plaintiff's lawyer. You know? Because you will, and understand this, you are going to lose cases, and it's going to hurt really, really bad. And you still have to come back the next day with as much passion as if you were going to win them all. And you're not going to be able to do that unless you love these people. You know, I've seen Brian lose a case. I mean, he's big, you know, and he's got that voice, and he's smart. He's one of the smartest guys I know, you know. But you want to see him just, you see that his heart is bigger than his rear end.
Is that discriminatory?
When he's talking about those clients that he's representing, and for him to lose a case, and he does lose cases too, he doesn't like to talk about it, it kills him. And if you're not that person, seriously, don't come. Don't come. You're not going to be happy. We're not going to be happy. But if you are that person, this is the most amazing job you'll ever have. When it's good, it's really good. I can't wait to get up in the morning. And that's been true now for quite a while.
Thank you. Mike?
Well, when you're the last person to talk on the subject, most of what's been said, you feel also. For me and Dean Phillips, who it's always a treat for me to come here just to see him, because he knows when I came here, he was the dean of the law school. I didn't come from a family of lawyers, and my father, you know, was an immigrant who had never been to school. But about 1 year, he was basically illiterate. My mom was born here, but had gone to high school. Nobody had been to college in the family. So for me, I was here, and I'm not kidding when I tell you, I didn't even know what law review was when I came to law school. It didn't really matter because I wasn't qualified to be. But maybe I would have concentrated a little more. So in law school, for students who are now in school thinking about what you're going to do, first of all, it's a very small percentage of the legal community of lawyers who have a business model like those people seated here have. A model where you have to put up your own money, you have to put up all the work, you have to pay the overhead in hopes that someday you're going to be able to go through the obstacle course of the cases we prosecute civilly and have a payday at the end. But the beauty of it and the richness of it is that you're representing people who 99% of the cases that everybody right up here now handles and has handled in their career is representing people who would have had no hope whatsoever to have their case heard in a court of law, but for someone who is willing to do all the work and put up all the costs. And so, as the saying goes, as goes the risk, so goes the reward. The risks are huge, but the rewards are really beyond any dream I ever had when I was here in the halls at Pepperdine with Dean Phillips, wondering how I was ever going to graduate. And so that's number one. As far as what I look for in a lawyer, sometimes I'm on the phone in my car completing a phone call before I get out of my car to go into the office, and I see the lawyers in the office showing up, and you could just see the way they walk to the office, the energy level and the enthusiasm, and you can't hide that. You either have it or you don't, and if you're not passionate about it, then there's no point in doing it. And so most people, when you look at the practitioners in our area of law, many of the highly successful people don't have fabulous academic pedigrees or things of that nature. They're, pretty much working class people who just know how to work. They have big hearts, and they work hard. Rare is the lawyer, and he's the most humble guy I know in our profession. Rick Friedman, who you talk to later, Harvard Law School. Some guys go to Harvard, and that's the first thing they tell you about.
At
He
least
never
within
tells you
3
about it.
minutes.
Yeah, within 3 minutes. But he doesn't carry himself that way. So, but those people are very, very rare. But the rest of us can succeed too. So thank you.
Thank you. Let me play off a couple of comments that Brian and Mike made. As a law professor, I see this all the time. Top 10% of the students is 1 in 10, right? So the people who are going to be eligible for the big firm jobs are going to be pretty few. But the people who can work in all kinds of different fields are much larger than that top 10%. I love, Brian, how you said take hard classes. I see that as a professor, that there's a temptation to take classes that aren't going to be difficult. If you have any concerns at all about passing the bar, which you probably should, take classes, UCC Article 2 Upper Division class or something like that. Thrilling topic, right? But you'll nail that stuff on the bar. So I want to reinforce that message from both of you. So a little bit more as students, and this is sort of a related question. We have approximately 160 students with us today. Our next question is, what do you wish that you knew when you were a student about the practice of law that you know today? And we'll start with Mark.
I'll be quick. I think that the business side of it, I had to kind of learn 4 years after I graduated from here, 5 years. I started my own firm through some unique circumstances. And so I didn't understand any of the business aspects, and I had to learn real quick on my own. So I think, just how you do things and the formation of a firm and some of those things. And again, it can be learned in a couple hours by, sitting with someone who's done it. So I think that's really key. The money necessary to do what you're trying to do. Every one of the cases that we have take a lot of finances, and you've got to front that, and you've got to be ready to take on every large insurance company. And so, just the ability to do that, other than just the passion, you've got to take steps to be able to do that. So learning a little bit of the business side earlier would have helped me. And sometimes, there might not be a class. You just got to go and surround yourself with people. My father was a pastor, so I didn't have a wealth of information on that aspect. So finding those people in your life that can help you with that.
Thank you. Mike.
So again, I think my comments are going to apply to those I think in this room that hopefully someday intend to be a plaintiff's trial lawyer. And one thing I will tell you that I did, a mistake I made, it was a mistake in the sense of it derailed my career for a little bit, but it did help me, is when I graduated, I took a job with a internationally renowned international aviation defense firm. I had clerked for insurance defense firms in the summers in my last year, and I thought it was a good mix, but I took the job primarily, to be honest, because it was a prestigious firm paying a lot of money. And I realized about 2 years into that career, that's not the side of the V I wanted to be on. And I wasn't really sure because we didn't have these kinds of things when I was here at Pepperdine 30, 40 years ago. So I think it's a mistake sometimes you'll make is you want to do that job that kind of, and the problem with most of you in this room is you have huge debt, probably, almost all of you. And you make economic decisions when you get your first job. I did. I had a couple $100,000 40 years ago in debt, so I took a job that paid a lot of money and was prestigious. I will say this, I learned from that. Learning from the defense side is another thing I will tell you. If you're going to be a plaintiff's lawyer, I love the lawyers that have worked on the defense side for a little bit of time because it gives you a perspective of what you're going to be dealing with. So I would simply say don't let the prestige and the money be the decision-making process if it doesn't have to be. The other thing I will tell you is most people will tell you, the young lawyers say, in law school they never really taught you how to be a lawyer. They taught you how to pass the bar. And you're going to learn how to be a lawyer. I would strongly suggest, I clerked after my first year back in New Jersey when I went back to get married. I clerked between my second year, I got a nice job. I actually clerked a lot during my third year. That is the best thing for you to do if you can fit it into your schedule and everything else, is get a lot of practical experience, because you'll have a better understanding of the practice of law as a litigator when you clerk a lot. But the last thing I'll tell you is, understand, if you're going to pick a career, understand the differences of the impact it's going to have on your life. Most of my friends, and that I've got a lot of them that went to corporate, real estate, that, high tower, silver tower job, their lives are different. Everybody in here I know is a trial lawyer. I see some of my friends sitting around, Jeff Wells sitting over there. We've been together a long time. It's a different lifestyle. And you got to make that decision early on, because sometimes that decision isn't made early on. You'll go work for another firm for a while, then you see about plaintiff lawyers, and I want to be one, you make that call. If you're going to make this decision to be a plaintiff's trial lawyer, understand what you're getting into. As Rex has talked about and everybody else, it's an emotional roller coaster, it's a financial roller coaster, and you've got to have the DNA in your mind and your body that's going to tell you it's the right thing to do. So those are the mistakes I want. It's not a mistake. It's almost a prefatory comment of what you want to think about early on in your legal education.
Rex.
I think the biggest mistake I made, and probably the biggest mistake that you're making, is in this profession, there's this prevailing attitude that there are really good trial lawyers, and we call them things like titans and things like that, which is incredibly damaging to us, by the way, because we might start to believe it. Because there's nothing further from the truth. We're only as good as our last case, is really what the truth of that is. But the prevailing attitude is that some of you are going to be really good trial lawyers because you got it. You got this talent you were imbued with somehow. And we believe that crap, and that's just what it is. The fact of the matter is that every single one of you who are sitting here, by nature of the fact that you are sitting here, tells us you're capable of learning each of those minute skills that is going to make you just mop the floor with your opposition. And especially if they're from those big, huge firms, especially because they take no risk. Everything's formula for everything they do. And, the thing I am most proud of in my life is that the lawyers in our office, every single one of them that decide they want to go to trial, and that's a decision they make. There's a lot of stuff to do that's not in the trial, in the courtroom. Every single one of them, by their second verdict, are hitting $1 million verdicts. And it wasn't because we hired exceptionally talented trial lawyers. It just isn't the case. We hired people that are very comfortable with the idea that the only thing they measure is, are they better today than yesterday? Just by a little bit. Are they better today? Is the Rex tomorrow a little bit better of a lawyer than he was the day before? What I don't want is those of you who are constantly comparing yourself to each other, and that you're measuring yourself by your standing in your class. Because trust me, if I wasn't the lowest in the class, I was really close to it. But as soon as I discovered that one thing, that the only thing I'm responsible for is that I'm just a little bit better than yesterday. And it was there all the time. You could read Galatians, and it's the letter from Paul, that's who you measure yourself against. Now, for getting the job, somebody's already beating you out because they met Rob in the hallway and they've already sent him an email, and they're developing the relationship. What ultimately, because it's become so competitive, is, are you developing relationships? Do not miss an opportunity to develop a relationship, because that's really, at the end of the day, that's who we hire, isn't it? They meet Alex, they meet Jason, they meet Kitty, and before you know it, they got an interview. And then if they get through Carroll, their life changes.
Thank you, Mike.
I think it's really important, and I know from personal experience that I didn't do that at the time when I was in law school, and that is to really think about the law. I knew it would be difficult for me to pass the bar the first time, so I made sure I took every bar review course there was and the writing course, and just really went to school on it. But I wasn't really thinking about the law. I was not thinking about the law as a philosophy and really understanding it until later. And there's no substitute for that when you practice. First of all, if you can specialize as early as you can in your career, decide somehow what it is that really excites you and where your passions are. And there's no way of knowing that until you get exposure. Work for a defense firm, work for the DA's office, work for a plaintiff's firm. Find your way if you really want to be in a courtroom. And once you decide that, first of all, learn everything possible about the law that relates to the field you've chosen. And that never ends. Personal experience, just about 2 months ago, I was reading an article. I love the column that Justice Gilbert puts in the Daily Journal. I'm a big fan of Art Gilbert. He's great. He's humorous. He's really smart. And in one of the articles, he talked about how he thought that the dissent in Palsgraf by Justice Andrews was right, and that the majority opinion I said, what? So I went back, we all heard Palsgraf and Polemis, we studied it. I had Ron Goldman for torts here, and he was a very colorful, wonderful professor. But I never really thought about it. So I went back and read it because of Justice Gilbert. I went back 2 months ago and read Palsgraf word for word. First of all, he's right. Andrews was absolutely correct in his dissent. And I thought Cardozo's decision was it was more like reading a philosophy paper. Go back and read that case and compare it to a current decision from the California Supreme Court or the United States Supreme Court. The world has really changed. But if you care about what you're doing, thinking about causation and really understanding it is so important because it'll make you be a better lawyer. And I know that it took me a long time to figure it out, but hopefully I'm improving. You continue to learn.
Thank you, Brian.
First, I wanted to correct something, Mike. I did go to Harvard, the Harvard of the West Southwestern. First thing I wish I knew was less is more. Example, I was sitting with one of my daughter a month or two ago. She was studying for a torts final. I said, let me see your outline. She gives me her outline, and I was impressed. It was like 8 or 10 pages. I mean, I remember in law school, people have these 100-page, 50-page outlines. Less is more. If you don't know it that way, you're just gonna get too bogged down. Number two, I wish I knew, and I still probably would have done it, but how hard this job really is, and the emotions, and how it affects your life. You have a trial, you have an injured client, and your family wants to go to this baseball game, or your kid has something, and you're gonna miss some things, and it's hard to balance. That's why it's important to balance. But the job, as I like to say, because I wasn't staying up all night, it's like cramming for finals every day. If you're in a trial, you're preparing for the next day, and it's not like maybe at O'Melveny and Myers they do this, where you have written out all your outlines or questions and your voir dire and your opening statement before you even start the trial. Most lawyers that up here don't operate like that because they have a lot of other clients that they're representing, and they just don't have the time until it's time to do it. Another thing I wish I knew, which I cannot stress enough, of how critical legal writing is. Everybody hates the class, but it's the most important thing for young lawyers. And once again, like I say, take hard classes. I would encourage you to take additional writing classes. I didn't, but I was working, and the lawyers basically trained me on how to write by just ripping everything that I was doing because it wasn't right, but I learned. And being a good writer, Mike Bedard, anyone will tell you that if you can understand something and explain it quickly writing, then you're a long ways towards success as a lawyer. And right now is the time in law school to really keep working on your style and your legal writing. Another thing I learned a lot of lessons, is don't think you know everything. Don't be afraid to ask questions. Lawyers like to talk. Lawyers, you'll see Rick Friedman, everyone up here, they love to talk about what they do. They don't mind at all if you come in and ask, hey, I was wondering, you don't want to look stupid. There's no stupid questions, I think. And when I first became a lawyer, I thought I was ready. You know, I was on the trial team, and I was just going to kill everyone. Which, number one, you learn that's not right. And I would tell my dad, who had tried, 500 cases, what a great cross-examiner I was after one trial. And he told me, when you take 1,000 depots, you might know something about cross-examination. So you don't know everything. It's nothing wrong with not knowing everything, and there's nothing wrong with asking lawyers about it because they love to tell you about it. Thank you.
Okay, Mike, we're going to go down to the end for our next question. This relates to law practice formation. You all have very successful law practices. What's a challenge that you encountered early in your career when you were putting your law practice together that might be helpful to students or other people who might be in the future putting together a law practice?
All right, and the way the original question came across was, what would you tell a student today who wanted to start their own firm?
Great.
And that's kind of how I prepared for this. And I will say this, don't do it until you have the experience. I think, of course, that's pretty commonsensical. You're not going to start your own firm until you believe you have the ability and capability to practice the kind of law you're going to practice. One thing I will tell you that I think is key today, especially, is have a detailed business plan. Know exactly what you're going to do, what type of lawyer you want to be, what kind of practice you want to have, and spend that time. Most lawyers, I think, that have successful practices that shift from either working for somebody or starting their own firm early in their career are more successful when they've actually planned it out. Don't plan out the next year. Plan out what you plan on doing the next 10 years, the next 20 years. You're not taught that in law school. There's not one. I don't think, Stephen, today you teach a class in law office management, do you? I don't think there is.
There is.
There is now? Well, finally, okay.
Sign up.
Okay, we didn't have that. So we all, if you're fortunate enough, my background was in economics and business in college, so I had a little bit of idea about business, but most of us don't know how to run a business. So make sure you know what you want to do. Key is how are you going to fund and finance that firm. Friends and family just go so far. If you're going to have a practice like ours, like Brian said, we invest. We're the only business I know of where you put all your own money up, you take all the own risk, and you don't even know if you're ever going to get paid. So to be successful, you have to be able to do that. I tell most of the young lawyers I talk to, make sure you have about 2 years worth of overhead in the bank somewhere, either from a very good uncle or parent or somebody else is going to help you do that. Here's the key. If you're going to be on your own, great, you're your own best friend. If you're going to start a practice with partners, partners in law firms are like spouses. They are. You need to make that evaluation. Not the same evaluation you make on a spouse. But a lot of the same considerations that you will have to consider because you'll spend more time with your partners than you will with your spouse in our practice at certain times of the year. So, and divorces occur. And so what I tell people is how do you avoid those divorces that we have in our common life and what you see in a lot of partnerships that end up breaking up. And that is know who your partners really are. And this is really important because I think this is where I've learned. I've had 3 firms, and my most recent firm I started a few years ago was after learning a lot of the things I made from mistakes, and right now I have the best partners I've ever had in my entire life. And that's because I got to know who they really were. I got to find out what was important to them outside the practice of law, because those factors will play into your partnership, what they're going to do, how hard they're going to work, the things they're going to do. And I also said, I always try to figure out what do they want at the end of the day? At the end of their career, what do they want to do? What do they want to accomplish? And so don't ever get into a partnership where you guys aren't on the same kind of wavelengths on those, because it can make being a partner difficult. Now, some partnerships are purely economical. You have your cases, I have mine. Those can work based on business principles. But if you want a partnership where you're going to be sweating together, fighting together, these are the things I look for. The next thing I'll tell you they don't teach you, which is I think is crucial in today's society, is marketing. Back then, when I came out of law, we didn't really think much about that. You developed your practices and your client list from your relationships. Now it's all internet. Now it's all technology. Now it's all social media. If you're going to start your own firm, learn how that works. I spend a lot of money now, and I know Brian does, and on having people show us how to do that so that we can be competitive. If you're going to practice law in a major metropolitan area in the country, you're going to have a lot of competition. If you're going to go back to a small town in Missouri, you may not, so it's a little different. So I think you got to make sure you understand marketing. It's very different 35 years ago than it is today. I also say, pick up on Brian's point, when you start your partnership and you're doing all those other things, don't forget you got to continue to learn. You cannot say, I've got everything I need. Do as much MCLA as you can, because as I agree with the comments made, the law evolves, You're not going to read cases all the time. It's about technique. It's about how to do something better, do that. And the last thing I'll tell you, the most important part about being successful in a private practice is your staff and associates. They are the lifeblood of your firm. You may be a great trial lawyer, and you may be able to make great closing arguments and pick a great jury, but if you don't have the right staff and associates to support you, you're going to have a hard time. So those are my tips for starting a firm.
Thanks, Rex.
I think he covered it all. No. I think the reality in this room is that many of you are going to have to open your own office if you want to do what we do. You know, it's an incredibly competitive field. The jobs are really, you know, there are this many jobs and there's this many of you. And you have to, you know, be prepared for that eventuality. But there are some basic rules that I think you have to recognize. You know, my wife and I have started the firm. It was just the two of us. But from day one, we never tolerated any type of toxic behavior in that office. You do not tolerate people who talk badly about their coworkers. You know, there's enough defense lawyers you can talk badly about. You know, you can get rid of that stuff, but you cannot allow that ever to be in your office. And every time we forgot that, it was disastrous results. The other thing that my wife was incredibly good at was she manages the debt, as little debt as possible. Because I've seen all of us have seen some great lawyers that crash and burn because they let that debt get out of hand. You've got to be willing to wait until tomorrow for the payoff. You know, we don't have debt. We own our own homes. We own the cars, and that's the way it was always. That was always the case. That we saved and saved and saved, and you go without if you have to. Now, you know, we're a little obsessive about it, and so maybe don't follow it 100%, but if you get what I'm saying, you have to prepare for 15 years from now, not for today. And yes, go to that small town in Missouri. We went to Lancaster. Why would I even think about coming down here and competing with these guys? Especially when I didn't have any money. You know, we borrowed enough to buy a computer and rent the office. That's all we had. I'm not going to compete with these guys. It would be insane to do that. The other thing is, you know, I'm a big family guy. My kids work there. My brother was a captain in the Highway Patrol and went to law school and came to work with us. I surround myself with people that I have absolute confidence in, that I can trust them, and who are not afraid to say, Rex, you're a jerk. Quit doing that. You know, that are willing to criticize and tell me what I'm doing right, but more importantly, tell me what I'm doing wrong. Those are the basics, I think, that once you get that down, you're going to be really successful, because so few people do it. I mean, it's not like it's hard, because everybody else wants to do it the easy way. I mean, thank God it's hard. If making money was easy, everybody would be rich. I don't want everybody rich.
Most of it's already been said. For me, when I got out of school, I was working for a lawyer in my hometown, which was just a local yokel practice, and I was already working for him. And then when I passed the bar, the same year I got out of school, passed the bar, he ran for office and left the office and went to Sacramento. So there I was, 24 years old, with a partner who was 27, who had gone to high school with me 3 years ahead. We really didn't know each other, but we just completely just jumped in with no training, no mentoring, no experience, and you know, we were walking, talking malpractice machines. We really were, but we had high standards on, you know, what cases we took. Basically, anybody that walked in the office with a temperature was a client. But it was a good experience, because sometimes these sayings that you hear, there's a reason there are these sayings that last for millennia. And one of the things I was reading about was that partnerships that begin with a friendship, a pre-existing friendship, rarely work out. Business partnerships that begin with friendships rarely work out, but friendships that result from a successful business relationship last forever. And I've personally experienced that because my first partner, I wasn't his friend, but he showed me what he was all about when we were together for 11 years, and we remained friends like brothers ever since. And the same with my current practice with Bill Chernoff and Ricardo Echeverria. These were business relationships before they became close friendships. And the rest has already been said, so I agree with everything else that the others have said.
Thank you.
I would say, unless you have to, don't start until you're ready. It's all about timing. It takes, to learn this practice, it takes time. I think you gotta get experience if you can, obviously financially. Maybe you don't have that opportunity, but myself, I started out in an insurance defense firm for a few years. Then I was in a very successful firm for maybe 17 years. And during that time, people would say, you win all these cases and you did this and that, why don't you have your own firm? And for me, the timing just wasn't there. I mean, there were a lot of other things in my life, and I was happy where I was and things were going fine. And eventually I did make the move to start my own firm. I'm glad I did. But the key is the team. I mean, you can't do it all yourself. Like I think Mark or Mike was saying, when you're in a trial, you're not doing anything else during the day. I mean, you're in the courtroom. So all these cases or whatever else you have going on, you have to rely on people to do that. And if you don't have a good team, you're not gonna win. And it's important, I always try to hire people smarter than me and to get a good dynamic of how the people, chemistry. And I always think of like a sports team. You know, everyone has different roles. Some people get to do the trials, some people do something else, someone does something else, but they all have to mesh and work together and have that same chemistry going towards the same goal, because it's a hard job, it's stressful. And if people can't get along, like Rex says, in a stressful thing, and there's deadlines and emotions, and people are needing money or they're hurt and they, you know, it's a tough case, and somebody on the team can't handle that, the whole team goes down. So it's important that you have a good team that can work together, because one person isn't making the firm.
So we've got Mark will be our last commentator on this issue. We have a very intriguing slide that's been up on the board. You may be wondering what that's about. Mark, if you would like, you can respond to the question and go into that as well, but I'll leave that in your discretion.
I'm fine if we're out of time. I don't have to do anything, or
I think I'm okay with the
one
time.
thing I learned was when to shut up.
We're okay.
When
but
you're
I'll leave it
winning,
up to
right?
you.
Are we?
We're okay, but I'll leave it up to you.
Okay. So one mistake that we just illustrated, and I'll do it in a minute and a half, was some of the most basic things you think of. Hey, the guy's on the stand. And one of the early times at a defense firm, I was in charge because I was there on an early weekend, and I got this guy as a witness. And they said, get this guy here. It was a security firm, and this guy was the best part of that security firm that we were defending was this guy was severely underpaid and had no training. And so I had to get him to trial, and you just think, oh, the guy's going to show up, and he's going to be honest, and you're going to take your licks. So I didn't control this guy, and so let's see. Yeah, you know what? I hit the wrong button. Okay, here we go. So anyway, just and I'll do it in 1 minute. This guy, I'm in charge of him. He's got to get on a plane in Portland, and he had this unusual fascination with LA. He grew up in LA. I was a little worried about him. But I was in charge of him. I got to get him to downtown LA courthouse, and I check in with him. Hey, you getting on the plane? Yeah. My firm is worried about saving money, and oh, well, I can stay with friends in LA. Okay, good. I'm going to fly you in on Sunday night. So he says, yeah, lift off. I checked the plane. Plane's on time. I'm not worried about him. But he loves LA, and he's in Portland, and I'm like, man, I'm a little worried. And so I said, check in with me when you get to LA. I've got to have him there on Monday morning at 1:30 in the courthouse. So hey, he doesn't need to rent a car. His buddy's picking him up. Another mistake. I didn't control it. And as you're hearing about this, trials are all night long. And my closet isn't great. My garage isn't great. But at trial, things got to be perfect. And so I'm responsible to get this guy there. And he checks in, and then he's drunk. And he hands the phone to his buddy. And his buddy goes, oh, we're going down the street in Century Boulevard. And I'm like, where are you? Where are you staying? And then this is where they're going, okay? And I've got to try to find him, and that's what I'm looking at. I'm like a Mulholland Drive hoping. And he's on Century Boulevard, and the next morning, it's Monday morning. And I get a call, and, you know, the guy doesn't sound well. I'm trying to find him. But all of that could have been averted, you know, had I been smart and just put him in the downtown hotel about 2 blocks, and it was 179. So you're going to have pressures from people to do it cheap. You're going to have pressures from people, and some of the simplest tasks just to get the guy on the stand can really be screwed up. And thankfully that case settled, and I was on an insurance defense thing. But if you do the simplest tasks well and get that witness there, you're going to have the next job. And I got signed this job just because I was showing up on Saturdays, as several of your people told before. But completing a simple task sometimes can be very complex. And that is one of my first terrible failures. Because this guy made it a lot harder. And I was up all night.
Thank you. Yes, Rex.
I just have one thing to add, and I know this from experience. You can be great, or you can drink, but that really is your choice. Thanks.
Thank you.
Let's
all
have a
going out
round
for
of
drinks
applause
now?
for, oh, sorry.